Court does call the case of People versus Gary Carmichael.
And then on behalf of people,
Assistant Public Defender Natalie Pate with and on behalf of Mr. Carmichael, who stands to my right. Please state your name for the record, sir.
Gary Walter Carmichael.
Oh, excuse me one moment. I don't have a motion.
Let me grab it for you.
All right. This is the people's motion. They're just bringing the paperwork. This is the people's emergency motion regarding bond.
yes, Your
So
Honor.
go ahead.
Just to start, the defendant was arraigned on January 3rd and was given a PR bond with the GPS tether no alcohol tether. By our request for $25,000 surety bond, a GPS tether and an alcohol tether. The events in this case stem from an incident between the defendant and his partner and the mother of their 2-year-old child. On that day, the defendant had been drinking. And the victim described that he consumed a pint of liquor and 2 tall white alcoholic beverages before this incident. And initially they had a verbal dispute that escalated into physical violence. And in that, the defendant originally took the victim's phone and threw it against a wall. He then proceeded to go to his gun safe and start digging around in the gun safe. Then he returned to the victim, charged at her while she was on the couch and held her on the couch and proceeded to strangle her. The victim described the defendant trying to strangle her 4 times and ultimately punching her in the face. She also reported to officers that there had been multiple incidents that involved domestic violence that she never reported, including an incident where he picked her up by the throat and threw her against a wall. During this incident, she was pregnant at the time. I also concerns officers noticed injuries consistent with her statements, including strangulation marks, a busted lip, and blood on her shirt, as well as furniture being out of place in the residence, table being turned over. At the time of this assault as well, there was a child asleep in the home. So I have concerns for her safety, the community safety, and I believe that the original bond as set was an abuse of discretion, given that he, in his previous criminal history, does have convictions related to drinking. So I would have concerns that he was not given an alcohol tether. I would ask that for the court to set his bond at our $25,000 surety bond with the GPS tether as well as an alcohol tether, given the seriousness of this case and the charges the defendant is facing.
Ms. Pate.
Thank you, Your Honor. Ultimately, we are asking that the court keep the monetary amount the same, being a PR bond. I do want to note that my client has had the GPS tether placed on him, and he does have no objection to an alcohol monitoring device of any kind being added as a condition of bond. Further, if the court would also like any sort of drug or alcohol testing apart from a scram or sober-link tether, my client would also be willing to do that as well. To my understanding, since the time of his arraignment and now, again, only being a couple of days, nothing has changed, and I do not believe there is any sort of bond violation or contact the complaining witness alleged since his arraignment or, quite frankly, his arrest. My client does have an address in Northville where he stays with his 2 children that are not with the complaining witness. His kids are ages 10 and 14. I do have this address in Northville. The complaining witness does not live there. He completely understands the conditions of bond of no contact and no go-to. It is my understanding the complaining witness lives in South Lyon, far away from this Northville address, and that she resides with their 2-year-old.
Define far away.
Not within the same block or neighborhood or anything like that. Obviously, it's within the same state. Northville being far or a distance from South Lyon. It is further my understanding.
They're actually relatively close at points.
I'm not going to go anywhere near.
Well, I'm just trying to figure out the distance between the 2 because
It's like probably 10 miles.
yeah, relatively close. All right, go ahead.
Oh, so 10 miles or a completely different city away from where he would live. He does not live with the complaining witness. We do acknowledge they do have the 2-year-old child in common. It is my client's understanding that that 2-year-old child is now staying with the complaining witness at that South Lyon address with the complaining witness and her mother. He completely understands the need for no contact order. He states to me he's willing to do anything in order to stay out of custody. He does have full-time work at a construction company. I won't put the name of the company on the record, but he does do that in home remodeling, and he's been there about 6 or 7 years. To my understanding, this is his only pending criminal matter of any kind. Further to my understanding, at the time of this alleged offense, he was not on probation, parole, or bond in any other matter. To my understanding, his most recent prior conviction was a 2013 drinking driving conviction, so about 12 or 13 years ago at this point. Miss Anderson from our office has been able to speak to my client's sister directly and was able to confirm where the kids are currently staying with their mother. Again, his GPS tether is,
His kids.
yes, his two children are currently staying with their mother, who is not the complaining witness. Again, he is not asking for any contact at this time. I won't comment on the actual allegations of the case itself, given I haven't even had the opportunity to review a police report or anything of that nature. But I will note that my client does deny these accusations and states that there is a lot going on. He does understand his bond conditions, especially the no contact, no go-to order, and he understands that, quite frankly, if there's any sort of whiff of bond violation or contact or text or anything, he would be right back in custody, and he does not want to do that. And this is his only pending matter, Your Honor. So we would ask that bond remains the same. Of course, he has no objection to an added condition of the scram tether or sober link.
Well, how does he plan on, to the extent he does, caring for the 2-year-old? Or his participation in that?
So usually I have full custody of my 2-year-old because of her situation that she's going through. She has a mental illness and has been in and out of rehab multiple.
See, hold on a moment. I don't know that you want to go there.
Me?
If I may, Your Honor, my client indicates to me that typically the 2-year-old does reside with him at his Northville address. His older 2 children is not in common with the complaining witness, and they reside with him. Their 2-year-old child often does reside with my client as well full-time. At the time of this offense, the 3 of them were together, and it is his understanding that the 2-year-old is still with the complaining witness right now. Initially, he was wanting to request third-party contact so he can still have contact with the 2-year-old, but at that stage, he understands if the court would not be comfortable with that.
Yes.
So I guess this allegedly occurred at her residence?
My residence.
Okay. Do you have firearms there?
Yes. I have old, like, hand-me-down, like, broken BB guns from when my dad passed away.
Yeah, BB guns in a gun case?
Yes, Your Honor. And I was able to speak to Miss Apple, who was his attorney at arraignment, and who he understands as a condition of bond, if and when released, he would have to turn those over to the, well, Northville Police Department or the Sheriff's Department, whatever would be closest to his
Are they
address.
just BB, or I shouldn't say just, but are they BB guns or we got something else?
My client is indicating just that, Your Honor.
How many?
3, and then like 4 it's in pieces. They were like from like the 30s, and 4 they're just from when my dad passed away in 06.
Well, since it was brought up, and at least in terms of the motion brought up in argument, the nature of the altercation was because of the pregnancy? Is that?
If I just have one moment, Your Honor. It started, in the report, it mentions they started to have a conversation about life in the future, and that's when everything took place.
Got it. There's only one alcohol related offense? Or does he have more?
There was one conviction from 2017 for an operating while intoxicated. There's a conviction for a dismissed operating while intoxicated from 2016 a 2014 reckless driving conviction, and then a 2013 conviction for operating minor with any VAC.
And the 2013 one was the only one I was aware of, Your Honor, and it sounds like the 2016 one was dismissed.
So we have a more or a closer one to today's day of an operating while intoxicated, right?
Correct, Your Honor. That's from 3/30/2017 out of the 1483 District Court. They did a preliminary breath test in this case, and I believe it was at a 0.189.
If I may, Your Honor, my client has zero objection to any sort of alcohol, scram, or sober like being added.
Anything.
Anything else from either side?
Other than the people, Your Honor.
All right.
Nothing additional, Your Honor.
What I'm gonna do in this case is how large is this gun safe that you have?
How large is my gun safe? Like, it's really mostly for paperwork. It's not big at all.
So would you say it's 2 feet, 1 feet?
Yeah, probably like 2 feet by 3 feet.
Is it an actual gun safe or is it something else?
It's an actual gun safe. Well, it's more of like a lock container, like a locker with a pin code on it.
Was there medical treatment that needed to be provided to the victim?
According to the report, she refused to seek medical treatment from the incident, but had the injuries the officers observed on her that we mentioned before.
Given everything that I've heard in this case, first thing that I'm going to do is I'm going to order that the defendant, prior to his release, also be placed on a scram monitoring system. Okay. With reference to in reviewing all of the other terms, I would indicate that the term as listed are appropriate. There is certainly an objection to the monetary amount. At this time, I would then change the monetary amount, and I do find that given all of the circumstances, the court does believe it to have been an abuse of discretion to set the bond at a personal recognizance, given the nature of these charges, the defendant's prior record involving alcohol, and his 0.18 at the time of this alleged incident. And so the court will set the cash component in the amount of $15,000 cash surety. All right. So I'm adding a tether, and it's a $15,000 cash surety bond.
Thank you, Your Honor.
Thank you. You got it.
Do you want a blue one?
This is a felony. We probably should have.